All right, welcome back. So we were under the framework for assessing the procedural fairness protections that will apply. We said there's a Baker case which says that the procedural fairness obligations will vary depending on the circumstances, essentially, and that there is no standard of review officially for procedural fairness decisions. You have to look at whether the procedure, quote, was fair in light of all the circumstances. Another thing that we alluded to earlier in the term, a couple of times I think, is the doctrine of reasonable expectations in administrative law. So in some situations, right, it will matter what the litigant expects the procedure to be. So sometimes, right, you'll have some discretion. We saw that doctrine apply in a number of circumstances. We said under discretionary power mostly, right? Discretion, the nature of the power is it can be exercised whatever way or not at all, right? Discretion means you have a range of possible outcomes, right? And you want the decision maker to be able to decide and to exercise a power that is less bound by specific rules and therefore more responsive to the instant circumstances of the case, often for the purposes of, right, having something that looks more like justice. We said, though, that discretion can be limited, not just by the decision maker themselves. For example, if they issue guidelines, it cannot, which they might have to follow, right? It can be limited by the expectations of the person. So, for example, if they are non-binding guidelines, that the decision maker, right, doesn't have to follow by definition because they're non-binding, they can over time become binding under the doctrine of reasonable expectations. The litigant can say, well, these rules have been, even though they're not mandatory, they've been out there for 20 years, therefore I expected them to apply. I adjusted my conduct as though they were binding, because even though they're non-binding, you've been applying them for 20 years. And therefore, I want them to continue to apply. I want to bar the exception there. And therefore, the discretion will be limited even though it's not directly limited by law because the guidelines are non-binding. Same thing for procedural fairness. The reasonable expectations of the person regarding the procedure, either because it's been followed in the past or because of the circumstances, will be a factor that will matter under the Baker framework that we just discussed. Okay, then the decision has to impact, quote, a right, privilege, or interest. So, what does that mean? It has to have an impact on you and on something that you have. It doesn't have to be a right in the traditional sense, right, which is why you have a privilege or interest, but it has to affect you in some way. So, for example, it can be taking away a license from you, or it can be not issuing you a license. Well, a license is not a right? You might not have, of course, a constitutional right to it. You might not even have a statutory right to it. Because the statute, the law, might say a license is discretionary, and therefore you have no statutory entitlement to it. Nonetheless, right, your interests or your rights or your privileges are affected if you are denied a license. And that is why you can seek judicial review of that. If a decision has no impact on you, it's not a decision to start with. Kind of like a court, right? A court is asked to adjudicate on an issue that will have an impact on people, on their rights, privileges, or interests. Same thing for administrative law. The two other words are important in that historically it's been limited, right, what you could or couldn't do. So, in some situations, because it wasn't as much of a right under the traditional framework, you could not seek judicial review of it because it didn't count as a decision. These distinctions have essentially become irrelevant over time, and the result of that is that it's expanded the nature of the potential impacts, and therefore the potential decisions having that impact, that are subject to review, including upon procedural fairness grounds. So you will have procedural fairness obligations apply even if a decision merely impacts a privilege or interest. There are very few things that are systematically excluded from the application of the duty of fairness and therefore procedural fairness obligations. Page 290, that's where you have that. So it can be, again, discretionary benefit, can be suspension of a license, can be something that's not a final decision, in which cases we said the level of procedural fairness obligations that will apply will vary, right? You'll have less procedural fairness, but nonetheless you'll have some, right? The decision is not structurally excluded from the scope of things you can seek judicial review from upon procedural fairness grounds. Okay, as we said earlier though, the failure to do something is always a decision. So if you're denied a license, it's the same thing as if you were granted a license, right? It's not because you were not granted a license that you have nothing and therefore no right to sue, right? The denial of a license is the denial of a benefit, therefore something you can sue. But similarly, the failure to exercise a power when you're asking for it is a decision not to exercise the power, and therefore you can't say, right, it doesn't count because the power wasn't exercised. One exception to the rule are decisions of a legislative nature. Because they're not administrative decision, same rationale as, right, the legislature. Of course, the legislature is not subject to review on that many grounds, right? So if Parliament passes a law, there's a very limited set of reasons why you can go to court and say it was done wrong, right? Often having to do with strictly following a procedure provided for in the Constitution, or violating your charter rights, which is also the Constitution. You don't get to say it's a bad decision and you want the court to review it. That's not the purview of the court. You have parliamentary, you have a distinct branch of government that's not subject to the review of the courts on the substance of what it does. So whether or not it's a good law or bad law, whether or not it affects you more than other people, takes away some of your rights, doesn't matter. The government gets to do whatever it wants, immune from judicial review as long as it respects some very limited obligations under the Constitution. Same thing in the administrative system. There will be an exclusion for decisions of a legislative nature. How do we know if it's a decision of a legislative nature? Well, it looks like a legislative decision. What that means is that usually it will consider public policy grounds. So it will weigh what's the good thing to do, essentially. That's what public policy means. It will seek to determine, right, what the best course of action is. So that's what you have the government do, and not an administrative decision maker. An administrative decision maker applies rules, right? It doesn't decide what the proper course of action is under purely moral or public policy grounds. Second, it's a decision generally of a general nature. That's also how you make the distinction and see that a decision is legislative and therefore exempt from procedural fairness obligations. Usually a decision within the meaning of, right, a decision impacting your rights, privileges, or interests is a decision that affects a limited number of people. Seems weird, but it's obvious, right? Just like the court. The court decides on a specific litigant, or a bunch of litigants, but not everyone in society. A law, in contrast, affects everyone in society. So you don't get to say, it affects me unfairly, as long as it's constitutional, or it takes away my property. Because it also does that for everyone else in society. And so if it's general, if it affects a greater number of people, it's more likely to count as a legislative decision. And you have that at page 292. Usually, right, the rationale is that you don't need the courts to control or review that. because the people do, right? Because people vote people out of office, directly or indirectly, it could be within the administrative system, therefore it doesn't count. You see that issue very often in the municipal context. That's why you have a bunch of examples with municipalities. And that's because they're created by statute, surprisingly, right? So provincial government, federal government, both of these derive their power from the Constitution. The Constitution, the Section 91-92 Constitution allocates specific heads of power to the federal and provincial governments. They can only act within their specified heads of power, and therefore their power is derived from the Constitution to the extent that they act within these powers. Municipalities, as you can imagine, have to have their power come from somewhere, and it's not the Constitution, because the Constitution only has two places, right, where power is derived, where power is granted, sorry. In fact, municipalities are statutory creations. They derive their power by delegation from provincial governments, usually, and therefore they're essentially administrative, like the Car Tribunal, like the Immigration and Refugee Protection Board. They are an entity created by statute. It's essentially administrative in nature, and therefore that will be bound by the nature and definition of the powers that were devolved by statute, and only that, right? Have no inherent power, have no grounds of jurisdiction as the provincial and federal governments do. Okay, page 294, of course, the labeling will not be dispositive. So, of course, the government doesn't get away from the application of these important legal and often constitutional principles by just saying a decision is legislative in nature. It has to actually be pursuant to the criteria that we saw. So if the government calls something a legislative decision by statute, for example, just labels it that, it is not sufficient. It's not dispositive, right? You have to actually meet the criteria. It's essentially useless for the government to do that. Okay, then we're back to the level of procedural fairness protections that will apply, which is something that we discussed many times already in the term. So, depending on, again, the nature of the decision and its impact on the person's life, the nature of the procedural fairness protections that will apply by virtue of the Constitution will vary. If it's a big decision, tough one for the person, you'll have more procedural fairness protections. You'll recall we went over the entire thing, I think, last week. So we said the very basic thing is you have to know what the case is to be met. You have to know what you're being, right, reproached with or charged with. To some extent. Doesn't mean you have to know the entire thing, but you have to know the substance of it. Then, that allows you to respond. The first way in which you respond will be, right, by producing documents to make your case. Then it will be by making oral representations. Then it might be by completing the record, by telling the government, this is not a full record. It kind of looks like I did something wrong, but if you had this other document, it wouldn't look that way. And therefore, I'll add it to your record. And then you have the more hardcore stuff, right? The right to call witnesses, cross-examine witnesses, eventually the right to plead some law, the right to be represented by counsel, and so on and so forth. So, page 300, it ranges from notice meaning, you know the case to be met, that's the basic thing, or consultation, again, a bit more because you have some input in the process, through an entitlement to make written and oral representations to a complete judicial procedure similar to other judicial hearings at the other extreme. The reason why you have, again, right, the minimum content of it as being able to somewhat make yourself heard, right, by making the case, is because otherwise it would be a violation of procedural fairness, right? It's no longer on the board, but I said you have a right to talk and be heard. Well, your right to talk and as a result be heard would be fully violated if you didn't know what you had to talk about, if you didn't even know what the case to be met is, and therefore what you're trying to respond to. Okay, page 303. Okay, you have two important principles that we discussed earlier, which are reiterated. First, you have to raise a procedural fairness issue at the first opportunity. And second, right, it is essentially a preliminary determination. So, first, raise it at the earliest opportunity. So, for example, right, usually the way this will work out is an administrative decision maker will have a procedure. Procedure will be insufficient in providing procedural fairness protections. Then you go to court, you say that. You say it's a breach of procedural fairness protections. I am seeking judicial review on that basis. And therefore, I want the court to quash, right, because that's the default remedy, as we said, namely cancel the decision that was rendered. Raise it at the first opportunity means you have to tell the decision maker first. You have to tell them this is not a sufficient procedure. And then they'll say, shut up, that's the breach of procedural fairness. Then you're able to raise that as well upon judicial review. Second principle, it's a preliminary determination, kind of like jurisdiction. Right? Again, we're not in the substance of the decision. So you're denied a license. The substance of the decision is, I am denying you a license because I think you're blind. The substance of the decision being reviewed is you saying, I'm not blind. You're wrong. On the substance of the decision, you denied me a license because of that. That because is not correct. In contrast, jurisdiction and procedural fairness are kind of preliminary determinations. Before that, you ask, does that decision maker have the power to grant or not grant a license? That's jurisdiction. And second, in doing that, then they follow procedural fairness. Because it's considered a preliminary determination upon judicial review, so namely it's one of the things that the court looks at upon judicial review before the substance decision. Because of that, right, it doesn't matter that the substance of the decision was correct. If you were not heard properly, if you weren't given the opportunity to be heard, it almost always doesn't matter that in the end it wouldn't have made a difference, because procedural fairness protections is really important in themselves, and therefore the court considers that first before looking at the substance of the decision, which can also be reviewed, right? You can say, this decision is unreasonable because it unreasonably determined that I'm blind. The court looks at procedural fairness protections before doing that, like jurisdiction. And the court often looks at procedural fairness regardless of the substance, often nullifies the decision, because that's the default remedy again, right? Quashes it, regardless of if it's correct in substance, if it's reasonable in substance, and therefore if the breach of procedural fairness was not relevant. Page 307, there is no requirement for there to be a record. We said that for the decision itself. We said there is no need for a decision maker to issue reasons for a decision, which is what a court does, right? A court issues a piece of paper called a judgment. The judgment said, this is how we have come to whatever decision we've come to. The piece of paper says, right, these are the ingredients we use, these are the reasons for the decision that we've come to. There's no requirement for an administrative decision maker to do that, because again, it's more flexible, efficient, and all that. And to the extent that there's no reasons for the decision, the court will still have to assess the substance of the decision based on the standard that applies. We'll still have to see whether the decision is reasonable. If it's a one-line thing that says this person is inadmissible to Canada, of course that line won't be sufficient to assess the reasonability of the decision. So the court will have to look at, say, the record. It's going to have to look at the documents that were before the decision maker, try to reconstruct what reasoning they came to, and see whether or not that reasoning is reasonable or not. Same thing for, again, the record, right? A tribunal doesn't have to produce a record of either the proceedings, right? So say type up what the people say as witnesses, or same thing as a decision. It might, in some situations where you have greater procedural fairness protections apply. An oral hearing, as we said, is not by default required. In fact, very often it's not. Very often you'll only have an opportunity to, right, be heard in writing or even just complete the record by adding documents. Oftentimes, right, the necessity of an oral hearing will arise when you have a credibility issue. So an oral hearing is helpful in asking tough questions of a person who might not be telling the truth. And therefore, if, say, the credibility or the testimony of the person who's advancing it is particularly important to the case, then it might be, right, depending on the importance again of the decision, a violation of your rights, of your procedural fairness rights, to not be able to cross-examine that person and test that evidence. Again, you have, right, page 309, the same spectrum and cost-benefit analysis that applies, right? You'll have to ask again, under the Mavi case, whether or not, how much these additional protections would cost, because a hearing's expensive, right? You need more decision makers, you need people to operate the hearing, you might need a transcriber to write down what was said, and you'll have, right, additional time for a decision to be made, namely the time for the hearing to take place, and you weigh that against the impact upon the person. So the prejudice, right, the impact on the person of not having these procedural fairness protections, and you see whether or not it's worth the cost, which almost always depends on the impact of the decision on the person's life. Page 313, we reiterate what I said earlier, I won't mention it again, regarding notice, right? So people have to be able to know the case to be met, right? That's the very basic level of procedural fairness, and you have essentially a bunch of reasons for that at page 315. So that is helpful in first, right, answering the case. Second, showing up at a hearing if that's the case. And three, preparing adequately, right? Because, see, my handwriting's been extremely bad. I think record-breakingly bad at the bottom of the board. But essentially, right, people have to have notice so they can prepare, right? So they can find the documents that they want to file, get the witnesses that they want to be heard. Otherwise, they might very well be right. They just won't have an opportunity to tell the decision maker in time that they're right because there isn't sufficient notice, because they haven't had the opportunity to prepare themselves for the hearing. Okay, page 315, what do you have to have notice about? That's actually important, so we'll do some erasing there. So, what do you have to have notice about? So, four things, as I said, are mentioned at page 315. And the case is at note 268. which is Lakeside Colony, what do you have to have notice about? First, the parties, right? Are you the person who a decision is being made about? Sounds kind of obvious. The issues that will be decided upon, the evidence that will be invoked, right? So what the government's relying on so that you can contradict it and perhaps add your own evidence. And finally, the consequences that may flow from the proceedings. So what is the government trying to do with that evidence? Take away your license, for example. That's the consequences of the proceeding, what you're trying to avoid by contradicting the government's case. The notice has to be sufficient, as we said, for the person to prepare, right? So they might not be able to prepare sufficiently. So the notice is not just in substance. So tell them about the important stuff. It's also in timing. Tell them about the important stuff in time. And the remedy usually will be, page 317, a stay. So of course you don't cancel the entire proceeding if there isn't notice ahead of time sufficiently, to the extent that the decision hasn't been made. If the decision has been made, you're kind of stuck with it. You have to go to court, seek judicial review, try to say, right, I didn't have sufficient notice, therefore the decision is unreasonable, should be canceled. However, you still have the obligation we discussed earlier to raise the issue at your earliest opportunity. So you'll be expected to raise the issue before the decision maker, the administrative decision maker. So you'll have to say, hey, this is not fair. I didn't get sufficient notice. And therefore, usually the remedy will be, right, for the proceedings to be suspended. So I think I misspoke earlier and said stayed. That's not what I meant. I meant suspended. So you'll postpone the hearing, for example, so that the person has sufficient time to prepare, which they didn't. What you won't do is stay the proceedings, right? The proceedings won't be canceled permanently simply because the person hasn't had an obligation and an ability to prepare. So it's prospective, not it's reactive, but not dispositive. Okay, then you have a bunch of things from the Sharkawi case, which is really interesting and you should read in your free time if you have any. Last thing I do want to mention is essentially an obligation from the criminal law from the Sitchcombe case, which is in the nature of the level of the disclosure that needs to be effected to meet the government's obligation. So it's essentially, again, from the criminal law, right? So the civil proceeding, the counterparty doesn't have the obligation to disclose evidence that's prejudicial to them. They can keep it for themselves, right? If you find out about it, you can ask for it and then file it in the court. But if they don't tell you about it, they don't have to tell you about it. They don't have to tell you, hey, I've got an email that says that we're wrong here. They don't have to tell you that if you're suing them. In the criminal law, they do, right? In the criminal law, you have to disclose all the evidence because, again, the decision is more important. Same framework as administrative law. The decision is more important. You're putting people in jail. It's really serious. Therefore, there's lots of procedural fairness, and that includes knowing all of the evidence against you very early. As soon as you're charged, right, you know all of the evidence. That's the whole thing, and that includes disculpatory evidence. So evidence that's for you, the government has to tell you about. So the government's not trying to prove that you did it. It's trying to figure out whether or not you actually did it, and therefore it discloses evidence that is prejudicial to its case and therefore helpful to you. In administrative law, kind of the same thing. The level of disclosure will vary. So these things will need to be disclosed. The extent to which, the level of detail in which they'll need to be disclosed will vary, depending on the importance of the decision on the person's life and the nature of the evidence, right? Again, similar to what I just described, that needs to be disclosed will also vary. That's a permutation of procedural fairness, right? If it's a big decision, has a big impact on your life, you have to be able to respond some more, and therefore you get more disclosure. If it's not, you get less of it, right? Again, that's all procedural fairness. It's all for the purposes of you being able to know what the case is against you in some way, being able to respond and subsequently be heard. And I think we will pause there for this week.